violators are only being charged with violations, so we want to make this charge a B misdemeanor.
Well, again, when I
read it again, Counselor. Read it again and then answer the judge's question.
It says, under the current law, these illegal MetroCard swipers can often, but not always.
But not first time.
It doesn't say first time,
Well,
but
that's my point.
I think what it's looking, I think when I read this, and I think it's a fair assessment of it, what they're addressing is the problem of how do we get these convictions when people are only being charged with violations. We need to beef this up. We need a starter crime with teeth.
And why is it starter crime, though? Why isn't
Well,
it?
because-
Why isn't it the
because I
person? Why isn't it the person who did it 10 times is being charged with a violation? If we understand where you're going in your argument, how do we know? Or that's why I asked you in practice. Was it that everybody was basically being charged with violations?
Well, because
I don't know about
everybody.
Had nothing to do with the first time or the 10th time?
I think it's all part of you take into account, when you're charging somebody, you take into account a lot of factors.
But does that mean that if this gentleman had been a first-time violator, you could not have charged him with forgery?
Oh, no, not at all.
Okay.
We certainly
So
could.
what it does
It's a question
mean-
of how you use your discretion.
So, that's right. So what it does mean is you, the district attorney, can sit there and say, no, I'm not sure, we've got too many Hispanics doing this. I think we'll charge them with the felonies, and we'll save the B misdemeanors for others. And that is your sole discretion. These are identical crimes, and you get to decide whether somebody gets a misdemeanor with a penalty of no more than 6 months or a felony that affects his job. He's going to prison. He's going to jail.
That's right.
You can't actually do it by national origin.
We would not, we would never do that.
You hope not.
I don't know.
And if
Hopefully
you
that's
did, that
true.
would be
And
a
if we did,
constitutional.
there are remedies for that. You would bring a Clayton motion and you would hold our feet to the fire.
I'm trying to be dramatic in it, in the sense that it seems to me that it's an awful lot of discretion to put in someone to say that you can charge somebody with a D felony or a B misdemeanor for two people doing the exact same thing on the same platform. You can say, you're a B, you're a D.
Right, and I think with larceny crimes and assault crimes and the whole range of criminal conduct, whether when you cause someone's death, you can charge them with assault, you can charge them with murder. There is a range of discretion, and that's exactly what we're in the business of doing, is exercising our discretion.
You want to put before the judge a criminal history? Is that what you wanted to do? You wanted to have a rap sheet before the judge so the judge would see what this person's history was and as far as fair beating?
I think in the face of $16 million deficits, the legislature was looking to help out the MTA and get a way to hold accountable not the first-time offender, not the mother with a few children who jumps the turnstile essentially, but the pernicious forger, the people who have made a career out of damaging the vending machines, bending the cards.
Sorry, those people you say should be prosecuted as forgers.
That is who Mr. Mattocks is, and that is who we prosecuted as a forger.
How did you know that? How did you know that? Was there a criminal history?
Well, it was. He was prosecuted at least 18 times for misdemeanor crimes and was convicted 18 times.
But you're saying the opposite now. You're saying that they were looking for a way to punish the guy who's the multiple offender, but it's the opposite. You were saying they're looking for a way to punish the first-time offenders so that they don't become an 18-time offender? Is that?
Yeah, I'm saying that, Mr. Mattocks was somebody who kept going to the same station,
but what was the
police
legislature?
were familiar with him.
Yeah, but what was the legislature trying to do? Finish that thought.
I think that the legislature here was recognizing that some people, some repeat offenders, weren't being caught because they were repeatedly being charged with violations. And
You're saying the legislature thought they had to have something between the violation and the forgery?
Yes, and to signal that we want...
The guy is not bad enough for forgery, but too bad for a violation?
That's right. I think that that's exactly what they were trying to do here. We want to keep a record. Since the current violations don't appear on the records, there's no easy way to keep track of repeat offenders. This bill would help correct this situation by subjecting the swipers to misdemeanor criminal penalties.
So now relate this to our case, to what you're saying is the...
Well, I think that because the legislature wanted to address the first-time, second-time offenders and try to provide a starter crime, in other words, create this B misdemeanor, they certainly, nothing in the history and nothing in the statute suggests that they wanted to take away the felony crime.
Could you go back, though? I guess I just missed that again. If the first time is a violation, The second time is a what? What do you do then?
Depending on all of the circumstances, you might go to the misdemeanor.
Well, no, didn't you just say that that's for the first-time offenders?
Well, I'm saying that it used to be, I thought it used to be that people were routinely charging first-time offenders with
No,
violations.
you said this statute was passed to get the first-time offenders.
I think that that was part of the intention of the legislature. They wanted to create a starter crime with more teeth than a
So
violation.
the violation isn't there anymore.
It's not that it's not there. I think that the legislature wanted to, you can always plead people out. That is always available to you. I feel that the legislature wanted to...
Let me finish. What I'm fencing you about you with is, you want to say that the B misdemeanor has called unauthorized sale of transportation services is identical to forgery. It's the same thing. And it's not forgery in the fourth degree or fifth degree, which would have made it seem like a graduated crime. But we've called it a whole new thing, and we've called it that because we want to get first-time offenders. But then you say, well, the first-time offenders are violators. And so this is, but we're going to keep the violators. We're going to have first-time offenders that we're going to have, I guess now is either violators or B misdemeanors, and then we'll jump to the D felony.
No, there's other options in between.
Wouldn't it strengthen your argument if you forget about first-time offenders? You're saying there used to be a big crime and a little crime, and then what, an in-between crime?
That's right. We want more options.
That's your explanation of the misdemeanor.
I think it
doesn't matter whether it's first or second or third or fourth, but for somebody who the prosecutor in his or her discretion decides is in the middle.
Is there any conduct under the misdemeanor crime that wouldn't qualify under the forgery crime?
Well, I think the misdemeanor crime really speaks to, the act of swiping a single person in. But the forgery is really a much more pernicious crime, as you can see. But
technically, isn't every misdemeanor also a forgery under your theory? Every violation of the misdemeanor statute also a forgery?
I think you'd be hard-pressed to say that if someone is possessing the forged card, that they wouldn't also be committing and swiping someone through, that they wouldn't also be committing
What about Mr. McCloskey's argument that it's not really purporting to be a perfectly valid instrument, it's purporting to be an instrument that was damaged by accident?
That's simply not the way this turnstile reader reads it. It is absolutely not true that the turnstile reader accepts the card, can detect that the card is invalid, actually detects that it's invalid or unreadable, and allows someone to enter
literally,
anyway.
the turnstile reader doesn't have a brain. I mean, the turnstile reader isn't human, so but the turnstile reader acts as though it's programmed to act as though the person who put that card through was somebody who had a card that was damaged by accident.
But that's like blaming the victim. That's basically saying because the system has this defect that it's not a forgery. And we don't treat banks that way.
The system made a choice to treat damaged cards as valid for one ride.
We don't treat banks that way. If someone comes up to the teller at a bank or a cashier at a store and has a forged check, has forged the signature on a check,
a store with a policy of cashing one check one check with a false signature on it?
That's exactly what happens. We go to the bank. If the card holder is at Chase Manhattan Bank, and somebody goes to Chase Bank and signs has a forged check with a forged signature, the teller doesn't go to the card and look at the original signature and doesn't call up the account holder and say, did you authorize this signature? We don't say, oh, well, too bad, it's not a forgery. It's still a forgery, even though the system doesn't catch it, even though there's a defect in the way the system catches it.
But if the bank has a policy suppose it's not a check, it's a bank card, it's an ATM card. You walk into the bank and say, I've damaged my ATM card, I need $100. You tell a very good story, they give you $100. In fact, you damaged it. In fact, you stole the card and damaged it yourself. That's a crime, but it's not forgery, right?
I think, but if you're damaging the card so that the person can't tell, the person where it counts, in this case it's the turnstile, can't tell at the moment you're using it, that's the forgery. And I say, if you're at the teller window and you hand the teller a check with a forged signature and the teller can't tell, the teller has no way of knowing that well, the teller could turn around and look at the signature cards in the back room, or the teller could call up the account holder and say, did you sign this check? Doesn't do it. The system doesn't allow for that. That's too onerous. But we don't say, too bad for the bank. Right? There is that defect in the system. You could have a foolproof system that would always detect a forgery. A forgery is always detectable.
It's not a defect in the system, right? It's a design of the system.
That's the way the system is designed.
Right,
We make choices about that.
But it's designed that's what it looks at when it goes through.
That's why the forgers are successful, because they're taking advantage of the way the system is designed. And you know, also to look at his example.
But the system is designed to give benefit of the doubt to a particular kind of customer.
And the system, the bank system is designed.
This crime was designed to pass Mr. Mattocks off as that particular kind of customer. Is that forgery?
It is a forgery, yes, by damaging the card in a way that fools the turnstile reader, which is the thing that counts. Not, you know, you're not fooling the bank president. You're not fooling the MTA expert.
Suppose he had damaged.
You're fooling the turnstile.
Suppose his card had been damaged by accident. He would have gone through exactly the way he did. Right? It would work just the same.
If it had been damaged by accident, yes.
Yeah, and he's supposed to be let through. That's the system, is to let him through if it's damaged.
Just the
by
way
accident.
when you come to the bank teller with a forged signature and she gives you cash, that's the system. That's the way it works. They don't call the account holder and say, Mr. Smith, did you sign this check? They don't do it. They pass the check, and then later on you complain that the check is forged, and then someone's arrested. That's exactly right. And I want to point out that in his example that he's been talking about, where you run the card through an 8-track tape, and then you take that and you tape it to a piece of cardboard, you know, that doesn't purport to be a card. That if you brought that to the teller, they wouldn't hand you a free ride or cash. That's much less like an MTA MetroCard that purports in all respects to be fully authorized and to have full value.
Okay, Counselor. Thank you.
Thank you very much. We're asking you to affirm this conviction.
Thanks. Counselor, rebuttal?
Thank you, Your Honor. Just briefly.
Mr. McCloskey, isn't, as Ms. McNulty points, isn't one of the differences here, picture someone like your client who's doing what they're alleging your client or your client's been convicted of doing, and somebody gives him $1, you know, for this MetroCard. They get the discount that benefits from it, right? They use it. Now, aren't they the ones that are guilty of unauthorized sale of transportation services, and isn't your client the one that's guilty of the forgery?
Your Honor, if a person sells a bent MetroCard to a third party, arguably the sale is for transportation services, and if I were a DA, I would argue that it wasn't the card itself; it was actually transportation services that were being sold.
If you did this and sold the card to me, and I used the card knowingly, what's my crime, if any?
Your crime would be could be theft of services, as my adversary points out. That is an in-between crime that actually did exist, and my adversary acknowledges.
But I'd have a defense that I didn't do it; I just bought it.
Well, you still stole services from the MTA.
But I didn't forge anything, and I'd be saying you forged it. All I did is buy it. So give me the misdemeanor and give Mr. McCluskey the D. I mean, is there some logic in that in breaking down the crimes in that fashion?
That assumes that somebody presupposes that somebody had to forge the instrument, right. And here I would still, if I were the DA, I would charge the person who originally bent it and sold it as the person who's unauthorized sold transportation services while unauthorized to do so. Now, I just want to cover a couple of points that my adversary raised.
If I jump the turnstile, that's a different crime than the 165-16 that we have here?
It is, because it's not done through use of a doctored fare card or an unlimited fare card. That's a very specific crime, but that would be theft of services, and again, the in-between crime. I just want to cover a couple of things. The system actually can detect when the card is invalid, and the reason we know that is because it does something exceptional when it can't tell whether that second field has value or not. In that case, it writes to the first field that it's been given the benefit of the doubt once. And that's something that doesn't happen when it can detect that the second field has 0 or has some other number. So it does something exceptional, and that's how we know that it detects that the card is invalid.
Suppose a bank, this is really, I guess, your adversary's argument. Suppose a bank has a policy, if it tells all its tellers, if you see a signature that you don't recognize, check it unless the check is under $5. If it's under $5, just pay it. And you go in with a false signature on a check under $5 and you get paid. Is that forgery?
Yes, it is, Your Honor, and I'm glad you
What's the
raised that
difference?
because it highlights the distinction between what my adversary claims is the proper analogy and what it actually is. If you took a check in to the contrary where the corner had been torn off so the signature line was not there at all, and you presented that for $5 and they paid you $5 in return, because you told them, well, I don't know, my dog ate the corner of it, or some other excuse, that would not be a forgery. The reason is the written instrument in that case does not have all of its constituent parts, and on its face is an invalid instrument. So thus it doesn't meet the statutory requirement for a forged instrument. Now, and in this case, no value is being added to the card. It's simply like tearing off the corner of the check. So,
Counselor, thank you.
Thank you.